Professor Bianca Guţan. She's a professor of constitutional law and international human rights law at the Faculty of Law, Lucian Blaga, University of Sibiu.
Thank you. Good afternoon, ladies and gentlemen. Thank you, Catrinel, for your very interesting introduction and for raising of some questions and even conclusions of what I want to discuss in my presentation. I also have to make a confession. Catrinel and I are still nostalgic of the René Cassin competition in Strasbourg, and we share these very beautiful memories. Human rights have become a constant topic of the political and legal discourse in Europe, especially after the fall of the Iron Curtain and the European integration of most post-communist countries. Not only states configured and reconfigured their legislative, constitutional and institutional constructions around this common denominator, but also the supranational European organization, presently called the European Union. Within these coordinates, to talk about human rights as an element of the European legal culture becomes more and more a commonplace. In time, human rights have become one of the main elements even of a European judicial culture. The debates on the European judicial dialogue and the judicial cross-fertilization are well known. The judicial dialogue, more vivid in the case of the supranational and constitutional courts, and more hesitant in the case of ordinary domestic jurisdictions, has as a main topic the actual level of rights protection, whereas the normative protection systems have known in the last years new levels of development. It suffices to mention the forthcoming adhesion of the European Union to the European Convention on Human Rights, but also the newly adopted Protocol number 16 to the Convention, all which will bring this dialogue to new unexplored territories. Evidently, the perception and application of the European Convention by various national jurisdictions depends fundamentally on the way in which the Convention had been introduced into national law, as well as, in some countries, by how constitutional jurisdictions shaped this relationship. And this brings us to the discussion on monism and dualism, which I will not insist on because it has also already been discussed. Anyway, beyond this classical distinction, monism-dualism, the reception of the European Convention also presents other peculiarities. As a general rule, in monist states, the Convention has become a part of the domestic law as an effect of ratification, whereas in dualist states, special laws of transformation or transposition were necessary. The problem of the European Convention's reception reveals, however, its true dimension when it comes to the practical application of norms, especially by national courts. That is why a brief comparative overview is useful, and I really want to mention some of the countries on which I have studied this matter. In Germany, for example, the best-known decision of the Federal Constitutional Tribunal regarding the application of the European Convention by national courts is the one given in the Gergülü case in 2004. Here the court said that, firstly, in Germany, the Convention has the legal value of a federal statute. Secondly, in case of a conflict, except when the domestic law gives more extensive rights, German courts have the obligation to interpret the domestic law, including constitutional law, in conformity with the Convention as read by the European Court of Human Rights. In France, it is well known the distinction between the conventionality review and the constitutionality review. The former is done by ordinary courts, whereas the latter is within the competence of the Conseil constitutionnel. A more particular situation is the one of the United Kingdom. British courts are in principle bound by the provisions of Section 2(1) of the Human Rights Act 1998, which states that a court or tribunal determining a question which has arisen in connection with a convention right must take into account any judgment, decision, declaration or advisory opinion of the European Court of Human Rights. In Britain, the British doctrine emphasized the ambiguity of this phrase, must take into account, and the juxtaposition of the obligatory must and the permissible take into account being unusual and a little unclear, but the courts are obliged to apply Strasbourg jurisprudence. However, British courts have taken different paths in their approach to applying the Convention. Some of them would blindly following the European Court's case law and would not depart from it without very good reason. Others are assessing the relevance of the Strasbourg jurisprudence, etc. How are Romanian courts behaving in this equation of applying the European Convention? One of the main general criticisms of the Romanian judicial system during the transitional period has been the absence of a jurisprudential coherence and the lack of understanding of its role as a fundamental rights guarantee. These past, I hope, unfortunate features applied especially in acknowledging by ordinary judges the existence and application of fundamental rights catalogues with superior legal values, including the Constitution and the international law. In cases related to the right to liberty and security, especially the conditions of pretrial detention, Catrinel has made reference already to the Pantea judgment, which was a consequence of this. One could find in the 90s arguments like judges are only subjected to apply the law and not the Constitution, unquote. In a famous 1999 decision, the Supreme Court of Justice expressed a common attitude among judges at that moment, according to which the provisions of the Constitution are not addressed directly to the ordinary courts which apply the ordinary law, but only to the legislator who must comply with the Constitution and bring changes to the ordinary law. As you can notice, the European Convention or international human rights treaties or standards were not present in the discourse. As for the Constitutional Court, it started to refer to international human rights law instruments more frequently beginning with the year 2000. The Supreme Court, reluctant at first, ended up by following in its steps and was followed at its turn by the other courts. On the other hand, neither the Constitutional Court nor the High Court of Cassation and Justice now have developed a strong jurisprudence of Gărgălu type, giving or addressing the national courts in their relationship with international human rights law. In fact, such a jurisprudence is theoretically hardly necessary, as Article 20 of the Constitution is clear enough. However, if applied, it might lead to a more constant reference to international catalogues of human rights, as well as avoid positions like the one expressed back in 1999. In recent years, the Romanian national courts have taken more seriously their role as human rights protectors, trying to deal more with the practical aspects of this protection rather than with the theoretical issue of the international law or domestic law relationship. Romanian judges, however, do not achieve what in French law is called a contrôle de conventionnalité. Very frequently, they only identify in the European Convention or European Court's case law arguments to underpin their decisions, although Article 20 of the Constitution would allow them to directly examine the conformity of national laws with the European Convention. Few judges, however, exercise this power, and I have the results of a recent inquiry at this stage only at an empirical research made among Romanian judges of all levels regarding the relationship with European law, including Strasbourg law. And an interesting result which I want to share with you today was the response to the question, how do you explain why Romania was repeatedly found in violation of Article 6 of the Convention and of Article 1, Protocol 1? 93.07% of the judges who answered the poll said that it was because of the bad legislation. Therefore, they were not even conscious of their power given by Article 20 of the Constitution to review legislation contrary to human rights treaties. To the same question, 17% of the judges answered that it may be explained by the fact that the Roman Germanic legal family does not allow precedent as source of law, whereas 13.85% said that Romanian judges are responsible of ignoring the European Court's case law. In the same time, surprisingly, 84% of the same judges considered that the European Court of Human Rights jurisprudence has the legal value of precedent for Romanian courts. Now, I will not comment these results. I will let you assess them. There will be a study published in the near future, so I don't want to interfere with that. The Constitutional Court, to go back to the Constitutional Court, its role in the constitutionalization of the legal system by permeating it with European human rights standards cannot be contested. One of the most famous examples in this is the one regarding the annulment application, recurs în anulare, and the court's contribution, although belated, to the elimination of this procedure from the Romanian legal system, as it was considered even by the European Court contrary to the legal certainty principle and to the right to a fair trial. Despite all the incoherences, there are no true normative conflicts between international law of human rights and national law in Romania. Certainly, the supranational human rights judges, in their important task of finding a common denominator to establish the protection standards, turn more and more to the national jurisprudence, and especially to constitutional courts one. National judges have anyway already been considered as better placed than the international judge to establish the exact content of the human rights, due to their, and I quote here the Strasbourg Court, direct and constant contacts with the living forces of their countries, unquote. Nevertheless, I have to emphasize here a great difference between the position of the national jurisdictions in Western countries and those in post-communist countries towards the supranational jurisdictions and international law jurisprudence, human rights jurisprudence. If the former have had periods of resistance or conflict, it was because, as President Jean-Paul Costas said, referring to the French case, there is sometimes also an irritation because these high courts think, with good reason, that they have for decades defended public liberties and human rights, and that the Strasbourg Court comes to teach them lessons of domestic procedure, which annoys them. However, the dialogue and cooperation found their place in this relationship, especially with respect to the Luxembourg Court, by means of the preliminary rulings procedure. On the contrary, constitutional courts and supreme courts of post-communist countries were not born as carriers of a European judicial culture tradition, having human rights as a salient element. They were entrusted the task to build, right away, their own already Europeanized judicial culture. And this is an extremely difficult task, especially if we take into account the inheritance of the totalitarian past. These institutions have mostly been created by new constitutions based on new principles inspired by post-war Western law. Nevertheless, they were born in post-communist transitional regimes, extremely difficult from the economic and political points of view. They have given their early decisions under an extraordinary external pressure, and most of the times they have not risen to the task, which is not surprising. However, there was little space left for conflict, given the political will of the governments of these countries to become part of the European club. That is why the two situations are not yet comparable. What the Western jurisdictions have achieved in over 50 years, the post-communist ones were required to do in less than 20. The most difficult task in this context is, thus, not changing norms, but mentalities. And although great improvements were done, as the last two CVM cooperation and verification mechanism reports mentioned, this is still work in progress for the Romanian judiciary. But, and I will end with this, the European Court seems to come to help Romanian and all national courts by this recent protocol number 16, which will allow highest jurisdictions of the states parties to obtain from the European Court advisory opinions on questions regarding the interpretation or application of rights and freedoms defined by the Convention. So maybe this will form another body of reference and will enhance the judicial dialogue across Europe. Thank you very much.